These signs are available at the Stand Together website, and they are available in 18 languages. Next slide, please. Now we will have Javiera Woods from the Office of Immigrant and Refugee Affairs to share about OIRA's program and resources.
Hi, everybody. Good evening. I'm Javiera Wood with the Seattle Office of Immigrant and Refugee Affairs, and I will be sharing with you an introduction to our office. Our office, OIRA, has the mission to improve the lives of Seattle's immigrant and refugee communities, and this work is done through policies, programs, services, and community engagement. Actually, can you go back one slide? I want to add a little bit more. Thank you. Our office is a branch of this local government, and we are part of the executive branch. We work with the mayor's office to support services throughout the city as well. We support with policies and advocacy at the local, state, and federal level. Similarly, we support with services and programs in partnership with many of our community-based organizations. Okay. Our office has several programs that focus on different areas of services and community needs that we want to support. Next slide, please. Our key services and programs are targeting all of these different areas. They include legal defense in immigration proceedings, ethnic media in communications and outreach support. We have the new citizen program that supports immigrants seeking to naturalize and obtain citizenship status. We have the language access program that, as you're seeing here today, can support with interpretation and access to language needs, supporting all city departments, as well as our partner organizations. Our Ready to Work program supports workforce development and English learning courses. We have immigrant safety planning, Immigrant Safety and Access Network, ISAN, for supporting families who have been victims of gun violence or sudden death in the families. We support with WAMAS, the Washington Migrant and Asylum Seeker. That's a housing support service for recent asylum seekers. And we have the Rapid Response Program, which I will speak in more detail in the next couple of slides. The intent behind all of these different programs is to support immigrants and refugees all around the city with all of these critical identified service needs. And we have tried to create a basis of infrastructure that can be then grown and supported further. Next slide, please. One of our biggest programs in OIRA is the Legal Defense Network. This program provides legal advice and representation for low-income Seattle residents, students and workers who are in immigration detention, facing deportation, or at risk due to immigration status. Something that I want to clarify is that our office staff does not provide representation directly. We I'm an attorney, but we do not have clients in our office. All of our services are provided, and our office manages the programs, and all of the services are provided through our partner organizations, our nonprofit partners who have the legal expertise and capacity to offer these services. So the Legal Defense Network provides removal defense and supports clients with filing applications for legal immigration status. We have many partners through this program, but some of our primary partners are Colectiva Legal del Pueblo and the Northwest Immigrants' Rights Project. While I understand that this is one of our biggest programs, I also want to be mindful that capacity is limited and that demand for these services is very large. And so if someone you know is in need of these services, you can contact our partner organizations. However, please understand that capacity, it is limited, unfortunately. So I want to be realistic with the expectations that we are setting. Next, please. The Rapid Response Program is the program that I manage, and it was established in 2025 in response to direct community feedback. We did an assessment and identified where there are gaps in existing services. And so from feedback from community and our partners and stakeholders, we identified key priorities: legal education, limited legal services, so not full representation, but at least consultations with immigration experts, and then advocacy and coordination. This program has been developed in partnership with many partners. Here you can see some of our key legal experts partners in their logos, but we have many other community-based organizations who we partner with for non-legal services as well. And they're all really relevant in us having outreach and ties to the community directly. Next slide, please. This is more details of the type of services that this program provides. You can receive up to 10 hours of legal consultations with an attorney who can help you prepare your own applications, and then you can file on your own. We also support representation for unaccompanied children, many community education events, Know Your Rights events throughout the city. You can access immigrant safety planning. So if you or a family member is at risk of detention or family separation, you can create a safety plan that will be notarized and plan for the care of children, legal preparations, and what documents you need to be prepared, and many other parts that are included within this document. If you want support filling this out and preparing this for you or your family, you can access this service for free through our partner organizations. This program also supports the Deportation Defense Hotline. If you see someone getting detained, you can call this hotline to report activity. And we have information sessions such as this one to keep our service providers up to date with legal changes. Next slide, please. Okay, so you can't see this very well maybe, but if you go to our website, you will be able to find the contact information for all of our partners, and you will be able to see what services they each provide, because they don't all provide all kinds of services. So you can, if you want help, you can find the organization, see what languages they speak, what services they provide, and contact them directly to request an appointment. All of this information is included on our website, and you can find the link to our website on the chat here. Next slide, please. If you want to learn more about our programs, upcoming events, and how to access services, please look on our website and also follow OIRA on social media, because that's where we announce most of our upcoming events. So that's it from me. Thank you so much, and I hope you enjoyed this webinar.
Thank you so much, Javi. Now we will have Colleen Fontana from Office of Labor Standards to provide information on Seattle labor laws.
Thank you, Gina. Hello, everybody. My name is Colleen Fontana. I'm with the Office of Labor Standards. If you're not familiar with our office, we support the labor rights in Seattle. And what this means is we support workers in understanding what their rights are in the workplace. And we also support employers and business owners in understanding how those laws apply to them and what their responsibilities are as employers. And we do this through investigations. We have a team that supports folks in looking into problems at the workplace. We also do outreach and education, such as these workshops, to support people in understanding their rights at work. We provide technical help and training for employers. So if you have a question or aren't sure how a law might apply to your business, you can contact our team and we can support you in understanding the law. And then we provide other resources and information that I'll share some links toward the end. We have a lot of languages available, materials in different languages on our website. So today we're going to talk through several laws, and I'm gonna give a lot of information. I know it will go kind of quickly, but we will make sure you have our contact information and also access to the website where you can find more details on everything. But I'll talk through minimum wage, wage theft, the Domestic Workers Ordinance, app-based worker protections, paid sick time, and then I'll close with protections from retaliation, and then what our office can do to support you. I want to also just say I'm not an attorney. We are not here to give legal advice. So if you have a really specific question about your situation, you can contact our office and we can set up some time to talk about that more one-on-one. And then also some other important reminders is that all of the rights that I'm going to cover apply to you no matter your immigration status. And we will not ask your status when you come to our office. It does not matter. And also, all of these protections apply to you even if you were paid in cash or are working under the table, even if you don't have a work permit, all of these protections apply to you. So I just wanted to say that right away up front. All right. So we'll start with the minimum wage. The minimum wage in Seattle in 2026 is $21.30 an hour. And most all workers in Seattle have the right to be paid the minimum wage, even if it's a workplace with just one employee. And this is just a minimum, right? So if you get paid more than the minimum wage, that's great. And also, if your employer told you that you would be making $25 an hour or more, you also have the right to the promised wage, is what we call that. So if there was some other agreement that you were going to be paid a certain amount, this law protects you to be able to have the promised wage as well. Moving on to wage theft. So wage theft is basically just not getting paid correctly for your work. Here are some examples. Wage theft is one of the biggest forms of theft in the whole country. It takes billions of dollars from workers all of the time. And here are some ways that that is happening. So maybe some of these examples sound familiar to some of you. Examples of wage theft could be working off the clock. This means working outside of your typically scheduled work schedule and not being compensated, not being paid correctly for that. It could also mean late or missed paychecks, being paid the incorrect minimum wage, not getting your meal or rest breaks, not getting the correct tips if you work at a restaurant where they have tips, or not getting your overtime pay if you're working overtime hours. So these are all examples of what wage theft could look like at your workplace. So this next section is about our domestic worker law we have in Seattle. And we also just passed in the state level, woohoo. So I'll talk first about Seattle. And this law applies to workers who work in and around private homes. So this could be nannies, house cleaners, gardeners, cooks, household managers, anyone who's working in and around a private home. And the rights that domestic workers have in Seattle include the right to the minimum wage, like I mentioned, the right to meal and rest breaks, the right to maintain their documents. So if you have your passport or your license, the employer, the homeowner, or the family that you're nannying for, they can't take those documents away from you. So you have the right to keep your documents. The law includes protection from discrimination. And then this last one here is just for live-in workers. So if you are, for example, a nanny who lives inside someone's home full-time, then you have the right to a full rest day if you're working at least 6 days in a row. So these are all of the protections that we have for domestic workers in Seattle. And we have a new state law that passed earlier this year. It's very exciting, lots of hard work from organizers and workers and hiring entities in Seattle across the state. So this law gives workers the same protections that we have in the Seattle law, but these are some additional protections that we have now because of the state law. So folks will have the right to a written agreement. This could be a contract, something written that talks about what the job will include, what kind of work it will be, what the hours might be. Workers have the right to advanced notice from the employer before ending the employment. And if the employer does not give notice, then they're required to severance pay. And then there are also some privacy protections included in this. So it means that employers cannot monitor workers in the bathrooms, bedrooms, or monitor communications. Sometimes this was an issue that came up with, if folks have heard of like a nanny cam or some kind of camera, or a lot of people have cameras around their home. So just some issues around privacy that came up. And then we will be updating some materials with this information. So look forward to some new materials coming soon, hopefully, so that you can learn all about this law as it starts to take effect. Okay, so moving on to app-based workers, Seattle also has 3 laws that are specifically for people who work on apps. And those laws are pretty complicated. There's a lot of information. So I'm just going to say up front that we won't go into all of the details, but I'm going to just share a little bit about each law. And then I'll put in the chat where you can find more information on our website, where you can get a lot more detailed on some of these laws. But a few important things to know is these laws apply to app-based workers working in Seattle for a covered network company that has at least 250 app-based workers worldwide. A covered network company uses online apps or platforms to connect customers with app-based workers. So some examples of these could be some of the food delivery apps that folks might use, Grubhub, Uber Eats, different apps that could apply under this. Who is not covered? Rideshare drivers are not covered. So if it's the apps that just take passengers, and then any apps where the app-based workers set their own rates or have pre-scheduled offers, these are not covered. So the first protection is the minimum pay ordinance, and this law gives app-based workers, covered app-based workers, the right to minimum payment for time and miles, flexibility protections, and clear information about the offers. And this is there's more details about this that will be helpful. I'm going to drop in the chat. We have a minimum payment calculator on our website that will be helpful for you if you have some questions about how to calculate and use this minimum pay. So I just dropped that in the chat to as a resource for everybody. Another law that we have for app-based workers is our deactivation law. And this gives workers the right to a notice of the deactivation policy, as well as the right to challenge a deactivation and the right to 14 days notice before deactivation that tells the worker why they're being deactivated. There are some exceptions to this in cases of extreme misconduct, or if there's a big violation of the policy. But this is a QR code to where you can submit a claim to talk to us if you think you have been deactivated unfairly. So hopefully this QR code works. I'll give you all a second to try it out on your phone, and this will take you to a page where you can submit your claim to connect with us about deactivation. I'll leave that up there for just one moment. Okay. And then the third protection is paid sick and safe time for app-based workers. And this gives app-based workers 1 day of paid sick and safe time per 30 days worked in Seattle. There's more information on our website about what this means in terms of worked in Seattle and what some of the requirements are around that. So I am going to drop here our link to where you can read just more details about each of the law. Oh, and thank you. I see Rivka put the deactivation link. Thank you for that. And here's our website where you can read more about all 3 of these laws. And the things that you can use paid sick and safe time for are the same as our other paid sick time law. So I'm going to get into those here in a moment as I move us into paid sick and safe time. So I'll just let folks think for a moment. I'm sure we've all been sick. I was just sick over the weekend. Sometimes you just need to take a day off, or sometimes you might need to take a day off and your boss calls you in because the restaurant's busy. And so sick time is really important. We need to be able to stay home and care for ourselves, care for our family. So I just want everyone to take a moment and just think about a time that you were sick and what happened. Could you take the time off? Did you get paid for the day that you took off? Did your boss tell you that you had to find someone to cover your shift? Maybe your employer asked you for proof, a doctor's note. So just think about those questions and we'll get into each part of them. So paid sick and safe time is paid time off for health or safety reasons. And once again, you have this protection regardless of your immigration status. All employees working in Seattle have the right to paid sick and safe time. Like I mentioned, app-based workers also have this protection and can use their paid sick and safe time hours for the same reasons that we're going to cover here. And this protection covers temporary, part-time, or seasonal work. So most types of work. And there are two kind of parts to this law. There's paid sick time and paid safe time. I'm going to break it down a little bit. So we'll talk first about paid sick time. This is kind of like it sounds. It's paid time off to care for yourself or for a family member if there's anything of illness, injury, or other health reasons. It can also be used for what we call preventative care, which could be a doctor's appointment, a dentist appointment. Maybe you have to go to the eye doctor. Those are all examples. And then the second half, the paid safe time, is often one that people are less familiar with, but this is paid time off for any safety problems. So this could include issues of domestic violence, sexual assault, or stalking. It could be that your child's school is closed because of a safety problem. And there's a new Washington State protection for this law that allows us to use paid sick and safe time for immigration court. So if you have to go to a hearing or something for immigration court, that's also a covered reason that you can use this protection. And that's a statewide protection. So let's talk about how many hours you get. It depends a little on the size of the company. So in Seattle, if you are at a smaller company that has less than 250 people, you get 1 hour of paid sick time for every 40 hours worked. So for example, if you work full-time and you're working 40 hours in 1 week, you will get 1 hour of sick time for working that 1 week. So in a month, if you work 40 hours every week, you would get 4 hours of paid sick time. If you work for a larger company that has 250 employees or more, you get your hours a little more quickly because you will get 1 hour for every 30 hours worked. So you just have to check first how many employees work at your company, and then we can help you figure out too how many hours you should be getting. You do not need to have a doctor's note until after 3 days of sick time in a row, 3 days of paid sick and safe time in a row. So if I'm sick on Monday and Tuesday, but I go back to work on Wednesday, my employer cannot ask me for a doctor's note. If I'm sick Monday, Tuesday, Wednesday, and want to also take Thursday off because I'm sick, then on Thursday, my employer can ask for a doctor's note. And this one comes up a lot, I think. So it's good to know what the law says so that you can say that back to your employer. Actually, I don't need to give you a doctor's note until after 3 days. You also don't have to give a reason or give a ton of details about why you're taking the paid sick and safe time. Sometimes people might ask, or maybe people want to have some kind of excuse, like know exactly what's going on, but you don't have to give any details. You can just say, I need to use my paid sick and safe time. And that's the only information that you need to give. There's also a waiting period that employers can require. So they can require a 90-day waiting period before you can use your paid sick and safe time, but you will still be getting your hours accruing. They will still be adding up over the time that you're working from your first day of work. And then after 90 days of working, you can use your paid sick time. So they can have this waiting period, but you will still have all of the hours adding up throughout that time. Okay, so that was a lot of information about a bunch of different laws, but one more important thing before I end my time is just to mention that we have protections from retaliation. And what this means is that it's illegal for your employer to take any kind of action against you for speaking out about your rights. And this could mean that they are making threats to you for about your immigration status, or maybe they threaten to fire you or cut your hours because you are asking about your rights at work. Sometimes it could mean discrimination because you're asking about your rights at work. All of that is illegal, and that's something you can report to our office. So just want to highlight that this is unfortunately something that does happen a lot, and we know it can be really scary to speak up about your rights at work, but that's why we're here to support you, and you can always talk to our office before you decide to do anything. So here's a little bit about how we can help you, and I think I'm about at time, but excuse me. We support workers who are performing work in Seattle. And like I said at the beginning, even if you're paid in cash, we can still help you. And here is how to contact us. Thank you.
Thank you, Colleen. Before we head to for our main presenter, just wanted to remind everybody that please be aware that this training is open to the public and will be recorded. So do not share any personal and sensitive information throughout the training. If you have any questions, please put it in the Q&A at the bottom menu and submit your question in the box. So now we will have Adam Boyd for our main presentation today. Hopefully. Oh.
Thank you, Jenna.
Yes, all right.
Hang on, let me just share my screen really quick. So hi, everyone. I am Adam Boyd at Gibbs Houston Pauw. We are a law firm in Seattle, Washington, focusing exclusively on immigration issues. And we provide representation basically across the spectrum from individuals to companies. And we're happy to be presenting today. Unfortunately, my associate Brianne was stricken ill and will not be able to join me today. So first, I want to go over the things that we are going to be covering with today's presentation. I know you just got a primer on some of the Washington state laws that protect you, but I'm going to go over a few more. There's one that's going to overlap, so we can skip right through that. Then we're going to be talking about your constitutional rights, what to do if there are workplace enforcement actions happening and you're there, some ways that you can best protect yourself and plan for the future, and then trying to educate you all on, the different areas where you might find protection or different variations of protection, the public versus private space. And I will be taking questions at the end. So the first section is going to be on what Washington laws have been enacted that protect workers that we haven't already gone over. So here's a list of a couple of the laws that have been passed in the recent years. 2019 is, of course, a little bit older, but you heard a little bit about the anti-coercion law. It prevents employers from using immigration status against their employees. You heard a lot about the paid sick leave for immigration proceedings law, the SHB 1875. We did not yet talk about HB 2105, the Immigrant Worker Protection Act. And we didn't yet talk about the HB 2355 for domestic workers. So I'm going to go over some of those in a little bit more detail. So the Keep Washington Working Act was one of our landmark pieces of legislation, basically delineating Washington as a sanctuary state. It prohibits our local law and local police, sheriffs, anybody who's working for the government to collect your information, stopping and detaining you solely for your immigration status, sharing your personal information with ICE or CBP, or allowing ICE to interview you while you're being held by state officials. Basically saying law enforcement or state agencies are not allowed to coordinate at all with federal immigration officials in their collection of data. So the one major exception to this is if federal immigration officials have a detainer for somebody. Our local jails are typically handing that person over if ICE is present upon that person's removal from the system. So when they're being released. This is a great law. It basically means we're not necessarily interfering with federal enforcement, but we're not going to be using state resources to help the federal officials enforce immigration matters. The reason behind this is when people are accessing state services, they should really feel comfortable that their immigration status is not going to be used against them. So this is a big slide about what local police, Washington State Patrol, and school officials are not allowed to do. So if anyone asks you about your immigration status, your place of birth, or nationality, unless they're related to an ongoing criminal investigation, you're not required to answer those questions. So a common example is a traffic stop. Has nothing to do with your immigration status or your place of birth. If you're being stopped by any of these officials solely to ask these questions about your immigration status or your place of birth, that is a violation of our laws. And then most importantly, these organizations or these state agencies are not allowed to share your information proactively with immigration and customs enforcement. We've seen a big tick up in the federal government trying to obtain access to state databases, including the Department of Licensing and including our voter registrations. And this law has helped our state push back against many of those requests. So the anti-coercion law, you did hear a little bit about the anti-coercion law. One thing that I always like to reinforce with people is the fines that can be involved for employers. So the first time fines can be up to $10,000, or repeat violations can be up to $10,000 per violation. And then the first violation can be $1,000. That is some pretty big incentive for employers not to use your status against you. The other thing that I like to point out as an immigration lawyer is if you are using this law to combat an employer that is trying to be coercive or abusive to you, you are also likely eligible for what's called a T visa. It's a victim of human trafficking. And labor trafficking is one of the main ways that people become eligible for a T visa. And if your employer is trying to be coercive with you based upon your immigration status, then you're almost certainly eligible for that. And if you are using this law and reporting to the Washington Department of Labor and Industries, you've likely already satisfied the reporting requirements for getting a T visa. And while that investigation is ongoing, you've likely satisfied the requirement that your presence in the United States is necessary and on account of trafficking. So if you're ever in a position where this law is relevant to you, you may have a way to obtain potentially permanent status here in the United States. We talked a little bit about paid sick leave for immigration proceedings. So one thing that I want to highlight is that it's not just for attending the proceedings, but it can be preparing for them. And it's not just for you. It also includes for you to help a child, a grandchild, grandparent, parent, sibling, or spouse, or anyone who regularly resides in your house. That means that you can just take your leave to make sure that you're able to attend these very important life events. Oftentimes, I have to remind my clients that this is the case because they're having trouble getting time off work when I'm trying to get them to come to my office to prepare for immigration court or to prepare their filings with immigration officials. The Immigrant Worker Protection Act is important for both employers and employees, but what it does is requires that your employer notify you within 5 days of any I-9 enforcement action that is taking place. This is required in Spanish, Chinese, Vietnamese, Somali, and Tagalog. So they must post notice in a public place and give all employees notice. The important thing about this law is, and the reason behind it is, at least during the first Trump administration, we would often see I-9 enforcements come before ICE enforcement actions. They are two separate things. One is basically looking to make sure that your employer's documents are all correct. And then the next ICE enforcement, immigration and customs enforcement, is more agents coming to an employer and trying to arrest any employees that they've deemed are undocumented. So we would see ICE use this I-9 enforcement tactic as a way to figure out whether or not there would be a high number of undocumented individuals at an individual workplace. So this is one extra level of protection where you as a worker will know if your employer is getting an audit of their I-9 documents. And then we did hear a little bit about the Domestic Workers Bill of Rights. Some important things are, applying minimum wage, and that you actually are supposed to get paid overtime if you're working over 40 hours, and that any contract must be in a language that you understand. It reinforces that even if you're working in a home, your employer cannot hold your passport or your immigration documents, that your employer cannot voluntarily allow ICE to arrest you in the home. This is a huge protection for domestic workers because a home is a place where you are entitled to a presumption of not being arrested. It's not a public place, even if it's not your home, and it is the home of your employer. This basically gives domestic workers the right to treat their place of employment as their own home. And then it also requires that you get advance written notice before termination and severance pay if appropriate, and gives a place to report, which is to L&I. So if you're ever having issues related to any of these, by all means, reach out to the people at the City of Seattle. So that's my brief overview of some of the laws that have been passed in Washington State. Now what I want to talk about are some of your constitutional rights. This is the introductory slide, but it says something incredibly important that not everybody knows, and that is every single person in the United States, unless you just barely entered the country and are caught at the border, but everybody else, regardless of their immigration status, has constitutional rights. So it does not matter what your immigration status is, you should be protected by the US Constitution. So we're going to go over a few key rights. The first would be your Fifth Amendment right to remain silent, and then your Fourth Amendment right against unreasonable searches and seizures. So your Fifth Amendment right is colloquially referred as your right to remain silent. This is incredibly important if there is a public interaction with immigration officials. In immigration enforcement, one of the only things that the government really needs to do is establish that you were not born in this country. And if they're able to do that, then it is up to you in deportation proceedings to show that you have a right to be in the country. If you can stop the government from getting any information about where you were born, we call that alienage, you can stop that process at the very beginning. And so the best advice is to stay quiet, no matter what somebody's asking you. And so we have a couple of what you should do's and what you should not do when you're having an interaction with immigration officials. So the first thing is don't resist and don't run. Immigration officials are not trained in de-escalation tactics. Unfortunately, it is up to you to be the calm one and make sure you are de-escalating the situation. The only thing that we recommend anybody say is, am I free to go? And if the answer is no, that means that they are effectuating an arrest and constitutional rights attached to that, including your rights to privacy. So if they say you are not free to leave, you would say, I'm exercising my right to remain silent and I want to speak with an attorney. And then you stop and you don't say anything else. It's one of those rights that's very confusing because in order to exercise your right to remain silent, you generally need to communicate something, and that is that you're exercising that right. If you say, am I free to leave? And they say yes, well, then you just calmly walk away. Now, this is really good in practice, but it's almost never going to go this smoothly. So we always recommend that people practice this. Look in the mirror and practice saying, am I free to leave? And I'm exercising my right to remain silent. I want to speak with an attorney. During these interactions, having those red cards that you'll see printed all over the place can really help, because then all you have to do is hold up the red card and stay silent. It's communicating basically the same thing. If you are detained, which is likely, right? I want to tell you that not saying anything is not going to stop immigration officials from arresting you. They're almost certainly still going to arrest you, and you have to be prepared for that. You must continue to exercise your right to remain silent, and you don't say or sign anything until you have a lawyer. And the only thing that I would want you to repeat is, I'm not saying or signing anything until I've had a chance to speak with my lawyer. Because if at any point in time during an arrest you admit that you were not born in the United States, that cuts off one of our major protections, which is suppressing any evidence that they get from an unlawful arrest. So those are what you should do. What you should never do is answer any questions about where you were born, especially not if it's a foreign country. You should not answer any questions about how you entered the United States. And we definitely don't want you to lie or give false documentation to immigration officials, because that's going to make things even worse. And definitely do not sign documents. It's pretty typical these days of ICE officials to try and trick people into signing voluntary departure documents and then just kicking them out of the country without giving them a full hearing. We wouldn't want anybody to have that happen. So, to recap, this tool of remaining silent and not escalating does not mean that you're not going to get arrested. But it is setting yourself up in the best possible way to protect yourself in deportation or removal proceedings. So the next major right that we're going to talk about is your Fourth Amendment right against unreasonable searches and seizures. And this is really tailored to the employment context. You obviously, or maybe not obviously, but you have a Fourth Amendment right to privacy in your personal effects and non-public spaces. So when talking about people who are at work, this would extend to a locker, a backpack, and other places that are generally not accessible to your employer. So in the context of ICE coming to somebody who is at work, while their employer may be able to allow ICE to come into the workplace, the employer can never consent to a search of your own personal belongings, even while you're at work. There are still things and places where you have a reasonable expectation of privacy, even if you're in a public or more than public space. So we'll talk about this a little bit more when I go into my public versus private space. So this is the case even if ICE has a valid warrant, unless your personal belongings, your backpack, locker, vehicle are actually listed on that warrant, you can refuse to allow them to search that place, obtain anything that's in that. And we have a little phrase here that you would want to practice, and that is, I do not consent to the search. Whoops. I'm complying because you have presented what appears to be a warrant, but I am not consenting voluntarily. That's a big mouthful, and you don't have to be perfect about it, but we would want you to practice saying this in case ICE or government officials are trying to get into your personal belongings. Even if that is the case, we're going to remind ourselves not to escalate, remain calm, take a deep breath. Even though it's a stressful situation, what we're trying to do is preserve our abilities to challenge anything in the future, not stop an overzealous, sorry, that's a bad word for the translators, not stop an aggressive ICE officer from doing what they're going to do. We just want to document our objection. Now, the difficulty in analyzing private spaces comes up with gig workers and particularly rideshare and delivery drivers because they're not classified as traditional employees. They're independent contractors. There are some laws that apply to them requiring that they get paid sick leave. But there are other protections that may not apply to rideshare or gig workers in Washington state. But the one thing that does still apply is your constitutional rights. So we would want to make sure that you are aware of that. You still have the right to remain silent, right? You can still refuse consent to search, even if it's in your vehicle, even if the public generically would have access to your vehicle. That's not really the case because you're only going to let somebody into your vehicle if they've already gone through the app itself. So what you would do if you're in the middle of a ride or if you're actually, waiting to pick up somebody and ICE approaches you, you would pull over, state that you're exerting your right to remain silent, and we would want you to try and contact an attorney. We would not want you to consent to search of your vehicle unless ICE has a warrant. And again, we're going to go over that in a little bit. This is, of course, unless you're within 100 miles of US border, or they have probable cause that there's a crime going on. But we would want you to state that you do not provide consent for them to search your vehicle. So that's a lot of information, but what we're going to do is try and give you some practical examples of public versus private spaces. And we're going to do both at work and a little bit in your private capacity. So the difference between public spaces and private spaces is that when you're in a public space, you generally don't have a right to privacy and anything that is publicly visible. So your face, your fingerprints, it's pretty easy for ICE, if they know who you are, to arrest you in a public space, sidewalks, public parks, bus stops, anywhere that the public can generally go into without requesting permission from the property owner or anybody else. Now, the one caveat is the city of Seattle has passed an ordinance prohibiting ICE officials from using public spaces as staging grounds or for enforcement actions, but that may not stop them from actually conducting arrests in these spaces. We would want to document whether or not you were arrested or had an encounter in one of these spaces where they were not theoretically allowed to go by the city of Seattle. But again, just like the constitutional rights, just because they're not allowed to do something doesn't mean that they're not going to. So those are public spaces, and these are some pretty common examples. What are some private spaces? Well, your home is the quintessential or the best example of a private space. Nobody should be able to access what's in your home without you saying that that's totally okay. The public can't just walk up and go into your home, and it has one of the greatest protections under our Constitution. Your home is your castle. But even within spaces that seem more public, there are private areas. Oftentimes, I tell people when looking at an employment space, like our office, for example, has a fairly public waiting area. The general public can come up and speak to our receptionist, and wait in our waiting room. But everything beyond the reception area is not really a public place. And so if anybody wanted to come and get beyond that reception area, we would say that there is a reasonable expectation of privacy. Even if your employer doesn't make this distinction between public and private spaces, there are almost certainly areas where the public doesn't have generic access and can't just go in. So even within large malls that are generally publicly accessible, there are back offices, there are closets, there are storage areas, and kitchens that are not generically open to the public. And these spaces, you would have a reasonable expectation of privacy, and ICE and government officials should not be able to access these spaces without a judicial warrant or without the consent of somebody who has the ability to let them into that space. And for domestic workers, because Washington has that law that prevents your employer from consenting to ICE coming into their private home, the house or the private property where you're working is considered a private space as it relates to you. So there's some differences between some public and some private spaces. And then this slide talks to you about what's the difference what's the legal difference between these public and private spaces. So if ICE encounters you in a public space, they do not need a warrant to arrest you. They can approach you and ask you questions. That's when we would invoke our right to remain silent. Just because they can ask us questions does not mean that we have to respond to them. You are not required to stop and answer the questions. You would just say, am I free to leave? And if they say no, well, then they're effectuating an arrest, and then we exercise our right to remain silent. And if they say yes, you leave. Even if they do grab you in a public space, that may not be a proper arrest. But again, we're not going to get into the legal gray areas there. We're just going to assert our right to remain silent and make sure we're not giving them any more information than what they already have. Now, When you're in a private space, ICE cannot enter those spaces without a judicial warrant. And I'm going to say judicial warrant is the key here. And we're going to go over a little bit later the differences between these two things. ICE almost always shows up with what's called an administrative warrant. It's signed by an ICE officer. And that does not actually allow them to enter any of these private spaces. So that's the private spaces we talked about before. That means your backpack or your locker at work, and it definitely means your home. The harder part is how do you ensure that you maintain your right to privacy, that you keep your right to privacy in these private spaces? You would ask if they have a warrant, and if they don't, you say, go away, I'm not letting you in. When it comes to your home, it's a little harder. We would recommend that you not open the door and ask them to hold the warrant up to a window or slide it under the door. But generally speaking, ICE will, if you get the door open, they will barge in, and then everything's over at that point. So we would want you to calmly and discreetly not open up any of these private spaces while you ask to see the warrant. And even if your employer is consenting to a search, or ICE has a warrant to search a particular place within, to search a particular workplace, that doesn't mean that their warrant necessarily gives them a right to search your private belongings. All warrants must be specific to the area to be searched and the item to be seized. So I threw out a couple of big phrases, judicial warrant versus administrative warrant, and now we're going to talk about the differences between those two, and I'm going to show you some examples. If anybody has any questions while this is going on, please feel free to use the Q&A section, and I will get to them at the end. So, a judicial warrant versus an administrative warrant. The easiest way to tell the difference between these two is by seeing who signed it. If it's a judicial warrant, it's always going to be signed by a judge, and it's going to say underneath the signature, district court judge, or their name, judge. It will be very obvious. If it's not signed by a judge, then it's almost certainly an administrative warrant. Those are signed by ICE officers, CBP officers, sometimes USCIS officers. There's a list of people that can sign those documents, but none of them are judges. The warrants are almost always going to have the name of a court, or they should have the name of a court on the top of them. And an administrative warrant is going to say something like DHS. It's issued by the Department of Homeland Security, not a court. And crucially, a judicial warrant must state with specificity, it needs to be specific, who's going to be arrested, what area is going to be searched, and what items are going to be seized. If it's not specific enough, then it does not authorize the law enforcement official to search an area. And we'll talk about this when I show you the warrants. Now, the administrative warrant almost always just says that they're going to arrest a particular person who's named on the administrative warrant, and it usually says warrant for arrest of alien. And even though it theoretically says that it's authorizing ICE to arrest that person, it doesn't even really provide that outside of public spaces. So, what does a judicial warrant look like? I cropped this into two pages so that you could see it, but usually this is really all on one document. So, some key things are at the very top, on the top left, you can see that it says United States District Court. The key word there is court. It says search and seizure warrant. The administrative warrants also say warrant on them, so that's not a big giveaway. But at the very bottom, where there would be a signature, and this is on the right side of the screen, it says United States Magistrate Judge, or judge's signature, print name, and title. So these are the key things that you would want to look for, is that it's issued by a court and it is signed by a judge. The other thing that people don't realize is that a judicial warrant has 2 pages. So what we just looked at, the district court and the judge's signature, is going to be on page 1. And then what you need to do once you verified that, okay, looks like a valid judicial warrant, you go to page 2, and this tells you what the warrant authorizes the law enforcement officials to search and seize. And if it's not defined with particularity, then you have a right to challenge that warrant. But what we're usually telling people is you have a right to limit law enforcement to searching whatever's listed on the warrant. So oftentimes it will be just one room, and they're only going to be authorized to seize one thing. And so even if you're scared because somebody comes and they have a valid warrant, you still need to keep reading and limit their access to whatever is listed on page 2 of that warrant. If they're trying to go into spaces or places that are not listed on the warrant, we would want you to say you're not authorizing them to enter those spaces because the warrant does not allow them to enter that area. Ideally, you have locks on areas that are, separate from where the warrant is. That's not always the case. But you should try and close doors and keep, areas private that are not listed. The one exception to this is if law enforcement officials are executing a valid warrant and they see something that is obvious evidence of a crime, such as drugs lying out in the open, you can't simply say, that's not listed on the warrant, you can't take it. There is a plain sight exception to the warrant requirement that allows them to seize things that are clearly evidence of a crime if they're laying in plain sight when they're exercising or executing an otherwise valid search warrant. So we're going to go back to our judicial warrant. This is page 1 of a judicial warrant. And we're going to compare it to page 1 of an administrative warrant. You'll notice at the top it says U.S. Department of Homeland Security. It says warrant for arrest of alien. So the U.S. Department of Homeland Security is not a court. Again, compare United States District Court to U.S. Department of Homeland Security. The bottom of it, it's going to say name and signature of officer. And this is actually pointing to the certificate of service. I actually want you to look a little bit higher. The arrow's in the wrong space. Above that box, it says signature of authorized immigration officer. That's actually where the signature is that we're looking at. And you'll note that that is signature of immigration officer and not a signature of a judge. Those are the key ways to tell the difference between a judicial warrant, which allows, again, law enforcement officials to go into these private spaces, compared to an administrative warrant, which does not allow them to go into private spaces. So If somebody is approaching you with a warrant, your first question is, am I in a public or private space? If you're in a public space, the warrant doesn't really matter because they can arrest you. You would default to, am I free to leave? And if not, I'm invoking my right to remain silent. If you're in a private space, you're going to insist on seeing a warrant, and we're going to go through, is this an administrative warrant? In which case, I'm not going to consent to a search. And then if it's a judicial warrant, we're going to limit them to what is on page 2 of the judicial warrant. That's a complex tree of what I want people to do. So at the beginning, we talked a little bit about I-9 inspections versus workplace raids. So I want to give everybody, because this is worker specific, a little bit of education on the difference between what we would call a raid and I-9 inspections. So the first one is, what is an I-9 inspection? This is where ICE, Homeland Security Investigations, sometimes CBP, give an employer a notice of inspection and often a subpoena. They want to get additional documents. And the employer has 3 business days from receiving that document to provide all of their I-9 forms and often additional payroll records, human rights record, or not human rights, human resources records to the requesting agency. If you're an employer and you're concerned about this, we definitely recommend doing an audit of your I-9s, because this can come at any time, and you only have 3 days to give over the I-9 documents. Oftentimes you can get an extension on the other documents that are requested in the subpoena, but there's a hard deadline of 3 business days on the I-9s. Now, the difference is workers aren't arrested as part of this. It's just a document gathering process that your employer or an employer hands over documentation. As we discussed at the top, employers must notify their workers within 5 days of receiving one of these notices of inspection. But that's usually after they've already handed over the documents. And again, as I said at the top, ICE often uses what they find in one of these inspections to conduct a future raid. So contrast that with a worksite enforcement raid. So this is where immigration enforcement or immigration officers show up and try to conduct arrests of people that are at a workplace. These are the things that make the news. Oftentimes, it's ICE in conjunction with other organizations. We've seen them use FBI agents, IRS enforcement agents, anybody who is deputized under the federal in the federal service has been roped into some of these larger raids. Because ICE's budget has expanded, more and more it's just ICE officers. But what they will do is try and cordon off the entire area, prevent people from leaving until they've had a chance to question everybody, and they will almost certainly conduct a mass amount of arrests. Now, there are some things you can do during this period of time to protect yourself, but that's a very different, it looks and feels very different from just I-9 enforcement. So this is a brief outline of what would happen during a raid. The first part is the investigation. Oftentimes you wouldn't even know that this is happening, and it happens for weeks and maybe months beforehand. As part of the investigation, it could be an I-9 audit. But what really triggers the raid is when ICE arrives in force with multiple vehicles. Typically, they will present a warrant, and we had them present some judicial warrants recently. So they're not always, when it's a large workplace raid, they are sometimes going through the process of getting an actual judicial warrant. Previously, we would see them almost always show up with administrative warrants, which if we had an employer or employees who knew their rights, they could have stopped those well in advance. Usually the agents will start questioning all the employees. Usually there will be a large vehicle for mass detentions, and then they will basically write reports of what had happened that day, and the media will get involved. I'm not going to talk a lot about the pre-enforcement investigation because I don't know that there's much that can be done about it. And we're getting close to the Q&A time. So instead, we're going to talk about what happens at the actual raid itself. The first thing we would want to remind everybody is stay calm. I have this mantra that I repeat in all of my encounters in my private life. If you get agitated, you're more likely to make mistakes. And the more mistakes you make, the worse things are going to get. And so the calmer that you can be during any of these high stress times, the better the outcomes are going to be. Generally, we would want to go through the same process. Ask for a copy of a warrant. Ask for them to identify themselves. They're going to ask to see it to get entry into a workplace, and we will want people to refuse until they've verified whether or not a valid warrant has been issued. Usually, as an employee, you have very little say over what's happening during this period of time, but we would want your employer to be insisting on seeing the warrant before allowing access to a facility. We had a dairy farm that was raided in I can't remember what state it was in, and I showed up with a valid judicial warrant, and the employer panicked and didn't bother to go to page 2, and page 2 of the warrant was completely blank. And so we would want all employers to be, aware of the warrant requirements so that they can insist that, all the documentation is in order before they just give access to the facility. If you're the first person to see ICE and you're not a manager, we would want you to alert somebody higher up, somebody with authority to either grant or deny access to the facility, that ICE is there, so that they can approach that person and do the warrant verification. So this is what we would want an employer to do. Just ask for a copy, review the scope of the warrant, that's page 2. We would want them to contact their legal counsel and then designate a person to interact with the agents to make sure that they're not going outside of what is listed on the warrant, and make sure that we have documented refusals of consent to search or seize things that are beyond the scope of the warrant, and document what is happening during the raid. One of the best things for a lawyer is if we can have simultaneous documentation of what happened, whether that's notes, video. It's a very chaotic thing, and if we have really good information about what's happened, it helps us make legal challenges after the fact. Again, asserting these rights doesn't mean that people aren't going to be arrested. It just means we're in a better position to challenge those arrests and detentions if we have people who have followed these procedures and good documentation of what happened. Here is where it's more specific to employees. What we want employees to do during this period of time is continue to maintain your right to remain silent and protect your rights to privacy. ICE agents can search specific areas and request records from your employer. They can take photos and interview workers, but they cannot insist that you give up your right to remain silent. think I'd talk about this in the what to do. So we're going to move on to that, but just stay calm, don't resist, and maintain your rights to remain silent. Yes, good. What to do during a workplace. So the first thing we want employees to do is the same thing as you would do when ICE encounters you in public. You would want to make sure that you're going to a public space in the workplace and shut the door so that if the warrant does not allow them into that space, you should theoretically be protected. Of course, if ICE tells you not to run away, you should not run away from them. But if it's before ICE officials have come in, we would want you to try to make your way to a private space, obviously not hiding in a cupboard, but if there's a private break room that they're not authorized to enter, you can go in there. If ICE officials confront you, you would ask if you're free to leave. They would say no, and then you would not engage. All we would want you to say is, I'm exercising my right to remain silent, and then stop talking. We also don't want you to carry or present fake documents. We would want to make sure that your phone and computer are locked and that they can't be unlocked with just your face scan or your fingerprint. That's because you do not have a right to privacy in your fingerprint or your face. But if you have to enter a code to unlock your documents, they can't force you to enter that code. Do not say anything, either with your voice or your behavior. And then we will want you to pay attention to everything that's going on and either take notes so you can write things down. You can record on your phone, but again, don't unlock the phone. Just use the camera portion without unlocking it. And then we'd want you to contact an attorney, preferably your attorney, and or local organizations that have engaged, rapid response teams. ICE will often engage in what we call coercive tactics by lying to you, either saying they're your friends or saying that they can bring, enforcement actions. They will lie and say that you're not entitled to see the warrant. They will produce warrants that do not describe what they're supposed to search and seize. Tell you that if you work with them, they'll make things easier for you. All of these things are not true. These people are not your friends, and all they're trying to do is get enough documentation so that they can put somebody in deportation proceedings. One thing that they will often do that is very tricky is they will say, everyone who's from Mexico, line up along this wall. Well, if you go and you line up on that wall, you're basically communicating to them, I was born in Mexico. And that's really tricky because you're not actually saying anything, but you're communicating it with where you're going. You can feel free to refuse to follow that command. They'll also say, everybody with TPS line up on this wall or raise your hand. Everybody who's applied for asylum in the US, come stand in this circle. Everybody who's in immigration court, come over here with this officer. We would not want anybody to follow those physical commands that are actually speech, that's communicating something. So if that's happening, we would want you to be prepared, and you would just say, I'm exercising my right to remain silent, and I'm not speaking by moving my body. And we would want you to try and help other people who are around you do the same thing. So, if you are involved in or you see an ICE raid going on, we want you to document as much as you can. Take your phone out and take a video. If they're getting aggressive with you about taking video, you can put your phone away and start taking notes. We'd want you to document the names of the officers there, what they're doing, how many there are, if they're arresting people, if you can find out the names of the people that are being arrested, you do have a right to document these things, especially if you're in a public space. ICE often gets upset when people are recording them, but that is your First Amendment right. We want you to take those recordings and get them to legal teams who can then use them to challenge anything that's happened to the people that were arrested. What we don't want you to do is get yourself hurt, because an observer is not helpful if their phone is confiscated and destroyed. An observer is not helpful if they're later arrested for punching an ICE officer or doing something illegal. And an observer is not helpful if they get arrested because they start running away and give, ICE probable cause to effectuate an arrest. Now, remember what I said at the very beginning. ICE is not trained at de-escalation. And so what our jobs as observers is to do is keep things calm and not escalate. They're going to try to make it an aggressive situation. We want you to be calm and collected and know what you're doing. The other thing that we would advise employees to do is talk to their employers if you're concerned about an ICE raid. The best way to be prepared is to make sure that everybody knows what to expect. We have some slides about how you can broach this with your employer. I would encourage you to get these slides if you're worried about how to start this conversation. I'm not going to go through them because our Q&A is supposed to start here in about 3 minutes, and I want to make sure I show you what resources we do have. So this is a sample way to start talking with your employers about immigration enforcement. The next slide is some of the good things. Oop, I'm getting an echo. Some of the good things that an employer would have in place if they're thinking about these things. You can feel free to take this list and give it to your employers. And some things that your HR managers should be thinking about. Now, they talked at the beginning that OIRA can help with individual safety planning. This is really helpful after a raid happens. You want somebody to be identified who can help your family. Contact your attorney, and make sure that you have somebody to help prepare you and show up if you are arrested. So we would advise that you consult with an immigration attorney if you're scared now and don't know what to do, because they're going to be in the best position to help you if you're caught up in any kind of enforcement. We want you to create some sort of communication plan of where your children are going to go, who they're going to call. If possible, we would want that person to have some sort of power of attorney that goes into effect if you're arrested, so that they can take your children to school or doctor's appointments. They can make legally important decisions. Oftentimes getting money transferred or cars sold or houses disposed of can be difficult if you don't take care of those things in advance. And then we'd want you to find at least 2 to 3 trusted people who know what to do if you are arrested and can help your family out. You never want to be in the position of being arrested and then trying to figure things out. So here are some documents that you can have prepared in an easy to access place. Your identity documents, your family documents, emergency contacts, and information about finances and housing. If you are arrested, and you aren't there to get these documents, you're going to want to make sure that somebody else can, so that they can help you take care of your family and your property. And then finally, we got you some resources that you can look at. Here are some phone numbers of people that you can call if you're in trouble. You can also always call your own personal immigration lawyer. So, the major points. One, always remain silent. We don't want to do ICE's job by admitting that we weren't born here. Remember, if you're in a private space, ICE cannot enter that space without a valid judicial warrant. You are not at the beck and call of your employer, even if you're undocumented. You have protections within the state. Your employer, if you are an employer and you get an I-9, you must notify your employees. And if you're an employee, you have a right to be notified. You have a right to take your sick leave to prepare for your immigration case, prepare documentation, and then make sure that you have a plan both for what you're going to do if you see ICE, if you encounter ICE, by practicing, am I free to leave? And I'm exercising my right to remain silent. Seems stupid, but just practice it in the mirror a bunch of times, because you don't want the first time you're saying that to be when an ICE officer is yelling in your face. If you have those things ready to go, you're going to be much better off. And then be prepared with your family so that they can take care of themselves if the worst happens. So now we're going to open it up to questions and answers. And Jenna, do you want me to leave this slide up or just stop sharing my screen?
You can stop sharing. That would be
okay.
Well, before we get to that, let's just thank all of our trainers for their presentation. Let's give a round of applause. You can click clapping hands or hearts or physically clap as well. Thank you so much. It was a great presentation. Now we're gonna go to Q&A section. Please put your questions in the Q&A. For those who are here listening in other language, please raise your hand if you want to say your question out loud instead of writing it down. Again, if you can put the questions in the Q&A, that'll be great. And if you are listening in different language, please raise your hand. So now I'm going to be asking you questions, Adam. The first question is, how can workers, general public, be protected from ICE when working outdoors? For example, in public parks or traveling via car, bus to another location for work?
That is a harder question. So we would want to know whether or not these are truly public spaces. So if you're traveling in your car, then you have a right to privacy within your car. Oftentimes, ICE will conduct arrests by pulling people over on the side of the street, and that generally means that they know who you are already. We wouldn't want you to refuse to cooperate because it can get pretty violent. But if you're in a public park, we would want you to repeat that script of, am I free to leave? And if not, I'm exercising my right to remain silent. They are going to be aggressive about, who are you? Where were you born? What's your immigration status? We just wouldn't want you to engage in those types of things. It's not one of those things where you can insist on seeing a warrant if you're out in public space. Now, one thing that you can do is if you are a construction worker and you're working on somebody's home, you can insist that that homeowner not provide access to the private property and insist on ICE having a valid warrant. So that's a big question because it covers a lot of different spaces, but we would default to our right to remain silent and not answering questions.
I guess my follow-up question, Adam, that includes the lawn of the person's home you're working on too.
Correct. Yep. It would include it would include everything that is like the private space. They can't just walk up to a home. Now, depending on where you are, you have more protections. So the closer you get to the actual physical home, the more protections you have. Ideally, we would have construction workers inside the house, but if you're doing like roofing work, ICE can't come up and start questioning you while you're on the roof for the person. It's a little bit harder if it's just like the very front lawn right next to a public sidewalk. You have fewer expectations of privacy, but that's where we would advise the people to then, ask if they can go into the house and then have the homeowner, or at least into a backyard that has a fence, and ask the homeowner to not consent to any searches of that space.
Okay, thank you. The second question is, how can we tell if a supposed judicial warrant is legitimate or authentic? Couldn't they fake one that has judicial warrant info?
Yes, I suppose they could fake a judicial warrant. That would be pretty egregious if that were the case. And so that's one reason why we would want to document what is on the actual warrant and get a copy of it. And so, sure, ICE could present to you what is a faked document. If you can take a photo of it and send it to a lawyer, ideally they would be able to identify that quickly, so that you would be within your rights to challenge it. But there's not much you can do to be prepared for that other than ensuring that you search that the judge is actually a judge in the court where the warrant is coming from. But I would tell people you would default to complying with what appears to be a valid warrant on its face. And if it's invalid, then you've got a challenge after the fact. So that's a more complicated situation. There's not really a whole lot you can do other than Googling the judge to make sure that they are within the judicial district where they're supposed to be issuing that warrant from.
Thank you. Question 3, how should you respond when ICE approaches you in your car? Do the protections that apply to a house apply the same way? What about if you live in your car?
Yes, you do have a reasonable expectation of privacy in your car. It's a little bit complicated because ICE often breaks windows to cars to arrest people and pulls them out. And, we don't want people to be putting themselves into a dangerous situation. Um, Typically, what I would say is roll down your window, ask if you're being put under arrest. And if they say, yes, we're arresting you, use your best judgment to not escalate the situation. Oftentimes they're going to arrest you no matter what. And so we would want you to calmly exercise your right to remain silent and, hopefully not be in a position where they're breaking into your car and dragging you out of it. They get really aggressive really quickly. If you're concerned about things that are inside your car, you can get out of the car and close and lock it, and then they don't have a right to search your vehicle. You are putting your physical body outside of the car, which is now a public space. But oftentimes, just being inside the car is not going to stop them from effectuating arrest. So it's a hard thing to advise of because you are correct. You have a right to privacy within your car. And they shouldn't theoretically be able to effectuate an arrest if you're in your car, but that's that's almost certainly not going to stop them. And so it's a judgment call on your own part about de-escalating and trying to protect areas that you can protect. So if you were worried about documents in your car, one of the best things you could do is, calmly open the door, get out, and lock the car. Um, that might scare the agents if you're getting out of the car. They might draw guns. And so the best advice is to sort of keep your hands in clear view, like resting on top of the steering wheel. Roll down your window and make sure you're complying with lawful orders. Because, like I said, when they're pulling cars over, they're almost certainly, they almost always know who the person is, and they're going to arrest you no matter what. And so we want to decrease the difficulty of that situation.
We got a follow-up question regarding the one that you just answered. What about passengers that are with you in the car?
So passengers also have a reasonable expectation of privacy, even if they're in somebody else's car. And so everybody would theoretically be able to refuse consent to search, because their ICE is going to primarily have identified the driver of the vehicle. We would especially want passengers to remain silent and not give their information to any ICE officials. And if it's safe, and they're arresting the person who's driving the car, we would want you to say, "Am I free to leave?" And if they say yes, we would want you to calmly walk away, assuming that you're not on the side of a highway and it's safe to do that. So if it's in a neighborhood or a parking lot, then we would just want you to leave as soon as possible and get to a safe distance. And that person, I would not want to be like sticking around as a document gathering person. I would want somebody else who was not in the vehicle to be able to come and create documentation. And so if you see a bystander, say, "Hey, ICE is, arresting that person. I need to leave. Can you go over and, at least make sure you see what's happening? And if you can, give that person your phone number so that you can get whatever documents they have or are able to, take."
For folks who are in the other language room, please raise your hand if you want to ask questions in your language. I know we're about at time and we have some questions, and so gonna try to get them to you quickly, Adam.
Right.
The next question is, if ICE demands to enter the lock portion of medical clinic, assuming that's like a treatment area, without having a warrant, should I call the local police?
Yes, I would think that that is a good time to call local police. Most medical clinics also have their own security. I would ensure that the security at the facility was aware, and again, it's one of those things where those places are often easily accessible, because they don't want doors to be locked so that people can move in and out of the medical facility. And so ICE will often take advantage of that and ignore any refusals to entry. But I would notify the security for the medical facility, and you could call police letting them know that ICE was there, they didn't have permission to be there, and you need some help.
Okay, the next question is, are apps that communicate eyesighting safe to use?
I can't comment on every single app, but generically speaking, yes. You're not typically adding your own personal data to these sites. Um, And they're not 100% accurate because some people will report seeing ICE when it's really just regular law enforcement. But the apps that I have seen typically don't ask for your own personal information. And that's kind of what you would want to avoid putting in there.
Uh, what counts as private versus public in a mixed location like monastery or motel? Does this distinction still matter when dealing with ICE visits?
Yes, the distinction does matter. So even within like a monastery, I'm sure that there are places where um, the monks or the staff live that are not generically publicly accessible. Those places are not public, and ICE would need a warrant to go into those places. Just like the example I gave of our office, our reception area is more of a public space, but if they wanted to come back and get access to my office, that's not generically publicly accessible. And so it's kind of it's not a bright line, but you've got to use your best judgment. And ICE is almost certainly going to ignore those artificial lines that you're establishing if they're not blocked by a physical barrier. And so if they're going into places that are non-public, we would just want you to document by saying, this is not a public area. You do not have authorization to be here. We're asking that you leave. But again, don't physically, you know, get involved with them because it's going to go poorly. Just keep saying those things and making sure that it's clear that they don't have authorization to be there.
Follow-up question. So if ICE is not granted access and intends to obtain warrant to force access, do some ICE officers typically stay at the location to prevent escapes while others go get a warrant?
Yes, if there's an issue with a warrant and they know what they're doing, then usually they will post people and not let anybody leave. That is a typical tactic. They don't want people leaving if they're running off to get a warrant, and they've already alerted everybody that that's what's happening. More often than not, they'll just stay there anyways and not bother getting a judicial warrant. They'll just charge forward and say that they have the right to be there anyways. But we would want that documented.
Great. We have 3 more questions, so just zoom in really quickly for you. If someone lives on a upper floor and it is not possible to slide the warrant under the door or through a window, what other methods can be used to serve or provide the warrant?
So I guess most places will have like an electronic buzzing system, and so they could hold the warrant up to like a video camera so you can see it. Um, Oftentimes they'll wait until somebody comes out of an apartment complex so they can actually go up to the floor where the person is. And so, they will knock on the door and hopefully you have a way you can see through it. But I would get creative. You can also, designate somebody to go down and look at the warrant without, giving authorization to come into the house. If they're after somebody specific, send a US citizen down to verify if there is a valid warrant.
Okay, 2 more. How close can a bystander legally get while recording without being accused of interfering?
Oh, well, that's sort of generic advice from like civil liberty observers is staying at least like 2 steps away from the person so that if they come at you, can safely step back and retreat. I mean, theoretically, if you're in a public space, there's not really a limit as long as you're not physically interfering with what they're doing. But we would want people to not be so close that it's going to be threatening to the officers. I recall doing some legal observer training where they recommended like 10 to 12 feet, to stay 10 to 12 feet away at all times, just because that seems to be a pretty safe distance where you're not imposing, but you're close enough that you can see what's going on. So 2 COVID lengths.
Thank you. The last question is, if ICE does not bring a judicial warrant and does not gain entry to the private place they wanted to enter, do they sometimes leave, get a judicial warrant, and return? If so, couldn't people leave during that time?
Yeah, we often don't see them taking that step of actually getting a judicial warrant. They certainly could. And yes, you can leave during that period of time, but ICE will usually post somebody to do observation to try and arrest somebody as they're leaving. And if you are leaving a private space, you're likely entering a public space where they then can effectuate the warrant. And so it's not as simple as ICE is gone, let's go. You would want to wait until you know for sure that the space is clear, if you were going to leave.
Okay, well, that is end of our questions. Could we share the screen again of the last slide? We can have that last slide up. Thank you. So thank you everyone for attending this training. Let's give all our presenters a round of applause by clapping hands, sending love to everyone. I really hope that this training was helpful and informative for you all. Could we do the next slide, please? And we plan to send out the recording and share handouts and the presentation slides. So for folks who didn't register, would like to get a copy of the recording presentation, please feel free to go back and register or email me at gina.young@seattle.gov. And I'll make sure to send you the link to the recording and the training materials. After this webinar close, you'll see a survey. It'll be really great if you can fill it out for us to receive feedback. If you have any additional questions, please feel free to reach out to me. And thank you again for everyone. I wanted to thank Adam for presenting, our city staff from Office of Labor Standards and Office of Immigrant Refugee Affairs. And so I want to thank you all for joining again and hope you all have a good night.